yours is Attorney Don Matthews.
Thanks very much. Good afternoon, everybody, and counsel as well. We'll hear from counsel for the appellant first, of course. You understand you have 10 minutes each. We'll give you an alert. So please start, as always, for the record, by introducing yourself and identifying your client.
Thank you, Mr. Chief Justice. My name is Jared Bianchi, here on behalf of the state of Vermont. Your Honor, the question before the court is whether lewd and lascivious conduct with a child, and therefore whether committing a lewd act with or on the body of a child is a felony which includes an element involving an act of violence. But before the court can properly reach that ultimate question, the court first needs to adhere to the standard applicable to what this court has said applies when reviewing legislative enactments. The standard here is that courts must make every presumption in favor of constitutionality, and that it's a heavy burden indeed for someone seeking to cast aside a legislative enactment. The trial courts here, however, the trial court failed to adhere to the appropriate standard, seemingly taking guidance from some recent decisions suggesting that such enactments are a nullity.
Mr. Bianchi, do you have a working definition of element that I could use, or that we could use?
Your Honor, I have taken the term element to mean the specific items or the specific facts that must be proven to satisfy a complete criminal conviction.
So you would say element means essential element as regards to the state's burden of proof on proving each essential element?
Yes, Your Honor, and that is the question that was dealt with in Filippo, which we, sorry.
No, go ahead.
So yes, we agree that it is the essential elements, not the behavior underlying the specific facts of a case, but it would be the essential elements.
Doesn't the attempt by the legislature here in 2602F invade the issue of who decides what the constitutional parameters are? Aren't they usurping that from the court by making a bold pronouncement that they've made?
We contend, Your Honor, that they are not, and that would not be the case unless they had issued such a pronouncement in a case which very clearly would not pass constitutional muster, such as trying to make identity theft a violent felony. This court's previous decisions addressing the degree of restraint and the presumptions that must be made in favor of upholding constitutional pronouncements suggest that that is how this court has historically drawn that balance. Although this court has the ability to determine that a statute does not pass constitutional muster, there is a process and a degree of deference that occurs first. So if a pronouncement like this in an aggravated assault statute may very well pass constitutional muster, while a similar pronouncement in a identity theft crime, that identity theft is an act of violence, may well not. And the way that the court would make that determination is by going through the process with respect to each pronouncement in light of the history and the legislative information that you have about the passage of the Constitution. And we talk about that some in our brief, and also within the broad contours of what can be appreciably considered violent, as that term is meant under this court's precedents and what the legislature has said.
Mr. Bianchi, you in your principal brief on page 18 appear to be arguing that for this court to determine whether or not the statute is constitutional, you're advocating, it appears to me, a rational test. And if I'm wrong, correct me, but your argument in your principal brief on page 18 provides no citation, and I don't know whether or not perhaps you're relying on the due process clause of our Vermont Constitution. So could you please explain that to me, what your position is?
And I appreciate that, Your Honor. I wasn't seeking to suggest that there is a rational basis review, as that term is meant sort of in the jurisprudence. And that was probably an inartful use of words. What I'm suggesting here is that within the confines of what we know about the passage of this particular provision of the Vermont Constitution and that history, that it fits rationally within what those framing legislators and voters intended. And in other words, that this would not be something that could be shown to be so beyond the pale under that it would pass the degree of scrutiny that this court has historically placed on holding that statutory enactments are not appropriate.
Okay,
So what
thank
does
you.
violence mean as you see it, Mr. Bianchi?
Your Honor, taking guidance from this court's prior decision, for instance, in Madison, that violence can mean a range of things, but an undue or coercive use of power or authority could well fit within that, especially within the context of a relationship with a child. So I'm turning to, I'm sorry, I lost my spot, Your Honor, but I believe it was Madison that recognized a broader definition, and we would suggest that if the statute can be interpreted to include that broader definition, that would be an appropriate definition for the court to adopt itself, the Madison test, if you will. The question for the court is there a way to find that this piece of legislation, 2602F, passes constitutional muster? And in light of that definition that's provided in Madison and some of the other decisions that are cited in the brief, we do believe that the court can find that this was a constitutionally sufficient pronouncement by the legislature.
What about psychological harm? Could that be considered?
Your Honor, I think that that the harm, the jurisprudence on issues of mental health and harm and dynamics of power does evolve, and it does seem that if a psychological harm results, that is a harm that is on the part of the body known as the brain. And we spent some time with a witness in this case developing some of the both the dynamics, the power dynamics that are inherent in a child sex abuse scenario, but also the harm that occurs to the amygdala. I think that the court can consider that as part of the package when it's considering whether or not a particular statute fits within the constitutional confines of what violence means. And when you combine psychological harm, with these abusive dynamics, these coercive dynamics, it certainly would seem that that kind of relationship and that kind of harm together can form what the Constitution considers to be a violent act.
I want to go back to the legislative pronouncement in 2602F for a minute. So a couple of questions. Number one, could the legislature say that driving while intoxicated, third offense, is a crime of violence for purposes of considering bail?
So, Your Honor, I think nothing, the legislature could pass that as a practical matter. And then it would be this court's responsibility, if challenged, to go through the appropriate process according to the restraint and deference that is accorded to those pronouncements. But ultimately, this court could find under the type of analysis that we are proposing for the court, ultimately would be probably a very difficult pronouncement to withstand such scrutiny. And so ultimately that could fail. And that was consistent with my example of, a 2602F in an aggravated assault statute that would likely withstand such scrutiny. But 2602F provision with respect to identity theft likely would not withstand that scrutiny. But it has to be undertaken with respect to each set of offenses for which such pronouncement has been made. A blanket prohibition on saying that the court does not need to consider the legislature's enactment for any crime would be too broad of a result. And that seems to have been the result that was reached by the trial courts.
You have 1 minute, counsel, 1 minute.
And Your Honor, if there are no further questions, I'll reserve that minute for rebuttal.
Okay, thanks very much. We'll turn to appellee. Counsel for the appellee, please introduce yourself and your client and then proceed.
Good afternoon. This is Dawn Matthews on behalf of Cody Shores.
Thank you.
Your Honors, we contend that the Vermont Constitution guarantees bail as a matter of right. And as such, this court has long held that the 1994 amendment allowing for the preventive detention must be narrowly construed. That's because the right to bail is concomitant with presumption of innocence. And the Vermont Constitution limits what the legislature can do. They shall have no power to alter, abolish, or infringe on the Constitution. And for that reason, this should be read very narrowly, and the legislature's pronouncement in F should essentially be ignored.
Ms. Matthews, doesn't the legislature have the ability to define a violent act?
They have the ability, Your Honor, to define the elements of crimes. They have and to come up with crimes and to legislate them, but they don't have the authority and to pass a statute that says what the Constitution means.
It just
I don't
doesn't say what the
understand.
Constitution
I'm sorry.
means. Go ahead. No, go ahead.
No. I think I'm probably following up with what you're saying, Justice Cohen. Go ahead.
This
Thank you.
doesn't say that it's constitutional or not constitutional. It just says that for purposes of bail, that it can be considered a violent act or a violent element.
And with all due respect, that's not the job of the legislature. That's the job of this court to interpret the Constitution.
But Ms. Matthews, isn't this just an expression of legislative intent? I don't see the provision 2062F offending the Constitution. I don't see it as amending, altering, or abolishing the Constitution. Rather, it's an expression of legislative intent. So perhaps you can tell me why that's not correct.
I suppose it is an expression. I don't disagree with Your Honor that it's an expression of legislative intent. I just don't think I just think that as such, it does not, in this context and in this kind of analysis where we're interpreting what the Constitution means and what the Constitution says, I don't think it has any weight.
Ms. Matthews, who wrote that bail amendment?
The legislature wrote the bail amendment, I suppose, and it passed the House and it passed the Senate, and then they came back in the next session and had to pass it by 2/3, but ultimately the people of Vermont voted on it. You can't pass a constitutional amendment without having the people vote on it. And so it's not, so whoever drafted it, it might have been someone at Ledge Council, but ultimately it's the word of the people of the state of Vermont.
Isn't 2602F an attempt by the legislature to define a constitutional term? And
exactly.
Isn't that our job?
That is your job. That is exactly what I am saying. I agree. And it may be an expression of legislative intent, and they may wish that that's the case, and they may wish it to be treated that way, but that's all that it is. It's a suggestion of the way the court should interpret it. It's not a pronouncement that's meaningful here, or it shouldn't be.
I'm a follow-up question in a slightly different vein. In Madigan, if I recall correctly, Justice Johnson suggested that the legislature could make a pronouncement such as what they have done. Was she wrong?
I think that she was. I think that it depends. Yes, I think she was wrong that the court could. That the legislature can tell the court how to interpret the Constitution. I think she's correct that if the legislature wants to do something or wants to indicate why they did something, they can certainly put that in. And if the legislature, in fact, if the legislature wanted to add an element of violence that was consistent with, they could add an element of violence to the lewd and lascivious conduct with the child statute, but they can't tell the court in a pronouncement, as Attorney Bianchi suggested. They could do it in the identity theft context. They could do it in the drunk driving context, but that would just be it would be what they would like to happen or what they think, but it's not a law that the constitutional interpretation is for this court. And that's because it's different than what Judge Novotny was suggesting. The legislature certainly passes laws, but they do not pass pronouncements of what's constitutional or not. A few years ago, we passed a reproductive freedom type amendment to enshrine in the Constitution in the Constitution this right to reproductive freedom that the people of Vermont felt was in jeopardy, right? And if the legislature can then say, well, we're passing a bill that says we're going to limit teenagers' ability to get Plan B, and we are doing that to comply with the statute that you wrote, and so we think that's a good. We think that passes strict scrutiny. So there's more than a rational basis, and for the legislature to tell the court that that's something that it should interpret as just fine in the context of an amendment that was passed by the people of Vermont is inappropriate. So I just don't think that it's useful. With respect to, and so in that respect, I guess if the question was Justice Johnson wrong that the legislature could tell what they wanted to do, the answer is I don't think that it's useful for the legislature to tell the Vermont Supreme Court how to interpret the Constitution. I do think that Justice Johnson was correct when she said that violence at a minimum should be the way what she took from Madison, the earlier case, and narrowing the view was that violence should be considered physical force employed so as to violate, damage, or abuse. And if the legislature wanted to change the statute, no person shall willfully or lewdly commit a physical act of force upon the body of a child under the age of 16, where such an act would violate, damage, or abuse the child. They could amend the statute to have that as an element, and then it would better fit. But they can't just do what they did here and say, this is how we see it, so that's how you should see it too, court.
Has this court followed Justice Johnson's definition of violence in subsequent cases?
They have, Your Honor, in the sense that, Justice Johnson wrote both Filippo, which limited this to a categorical analysis, and then she authored Madigan. And then the court hasn't really dealt with that until we saw this come up with stalking in Bedemin. I mean, there are a couple of courts that haven't followed it. Sure, there's Judge Tomasi writing for this court in two different circumstances. Looked at the dictionary definitions of violence and considered, what that might apply in manslaughter and in aggravated assault with a deadly weapon. But and I don't.
You have 1 minute, counsel. 1 minute.
He didn't necessarily adopt Madigan, but in looking at the elements of those crimes and in looking at the different definitions, he was able to find that both of those crimes did require and did have an element of violence that would allow for a hold without bail. I don't know. And then in Bedemin, and then there are the two judges here, Valenti and Barra, who also agreed that I believe with a narrower definition of violence. If there's nothing further, I will rest my case.
Okay, thanks very much. How much time does the appellant have, please?
The appellant has 50 seconds remaining.
Counsel. I think you must be muted. Attorney Bianchi.
My apologies, Your Honor.
Yep.
Will move on quickly. The appellee is referring to a decision by Judge Valenti, consistent with the one in this case. It's the state's reading that in both of those cases, the judges felt really bound by Beldeman and Madigan in a way that we believe was not accurate, but in either case, not that they would necessarily reach the same result, but that was the law that they were required to uphold. Further, Your Honors, this court's not ever expressly required physical violence to satisfy the violence prong of the analysis. Indeed, the constitutional provision at issue includes violence in the qualifying crime prong, but speaks of physical violence. In other words, it includes a different term in the conditions prong. And I see that my time is up, Your Honors.
Okay. Thank you very much. Please call the conclusion of the hearing.